Many service members walk into custody meetings braced for a fight, carrying a specific anxiety. Their career will cost them their children. This often stems from a fear that a judge will look at an upcoming deployment or a training rotation and conclude that a parent in the military simply cannot be present enough to remain a primary guardian. It's an understandable worry. The stakes are high, and the fear is that a temporary set of orders will quietly turn into a permanent loss of parenting time. While these concerns are common, Virginia law provides a much more protective reality for military families than many service members expect. Virginia law treats military service as a logistical challenge. It is part of the practical picture of a child's life, which the court evaluates based on how to best manage a schedule. Approaching the case through the lens of logistics allows a service member to move past paralysis and toward the strategic planning required to protect their bond with their child. Virginia custody centers on one standard: the child's best interests. The court weighs statutory factors like the parent-child bond and daily care. Within this framework, military service is just a scheduling variable to manage. The court's goal is to build an arrangement that accounts for the realities of service, rather than using those realities as a reason to diminish a parent's role. Judges are looking for a plan that works. They evaluate how each parent supports the child's well-being, using military status only to understand the practical timing of when that support happens. When the law requires this level of focus on the child's welfare, military service loses its power to be used as a penalty. It simply becomes a manageable scheduling detail. Addressing these scheduling details happens through the drafting of the custody order, where specific provisions are used to manage temporary absences. One major provision is the ability to delegate visitation. Virginia law allows a service member to pass their parenting time to a close family member, like a grandparent, while they are deployed. This ensures that time away for the country is legally recognized as just that, time away. It is not abandonment, and the law protects the parent's right to resume their schedule upon their return. When orders arrive suddenly, the law allows expedited hearings. Absences are resolved quickly, avoiding long legal backlogs. Without these specific protections written into an order, a service member is left vulnerable, forced to negotiate their rights under the time pressure of an active deployment. Virginia provides a framework of protections designed to ensure that the demands of service do not result in a loss of custody. However, these protections only work if they are established before they are needed. Waiting until orders are in hand often means reacting too late. The most effective protection is a proactive custody order that specifically outlines how deployment, training rotations, and permanent changes of station will be handled. This provides the service member with a secure bond to their child and gives the civilian parent a reliable, predictable plan to follow when the other parent is away. When an order is silent on these issues, a foreseeable event like a deployment can quickly escalate into a legal crisis. Proactive planning keeps the focus on the child rather than the emergency. A service member's role as a parent is secured through the quality of their legal planning. The law protects those who prepare for the rhythms of military life. No parent should have to choose between their service and their child. By focusing on the best interests of the child and planning for the realities of the uniform, they don't have to.